Save for one practical point, which is that try as we might, we've not been able to get our speaking notes across to anybody to print them. So all I can suggest, in order not to delay matters, is that we'll speak to them and then try and, once we've got Wi-Fi or better Wi-Fi, send them across so that you then get a hard copy.
Yeah, that would be helpful. Yeah, if you can send them in to Mr. Wordsworth at Inspectorate, he'll then distribute.
Just to manage expectations, they're only speaking notes,
yeah.
So it's not intended to be anything more formal.
You'll recall from another inquiry that we were in, I was having issues of not being able to access. So yeah, we all understand that technology sometimes lets us down.
It has certainly defeated us today. The Epping Forest Heritage Trust is a charity, registered charity, and in our notes we've included the registration number. Its focus is the preservation of Epping Forest, and its charitable purposes are aligned with that. The Trust is concerned about the appeal proposal. Its first representation was made in 2019. Matter of fact, before either of us were involved with the Trust, but notwithstanding, since then, the Trust's concerns about impacts on the forest have not been wholly assuaged, in particular in relation to employee trips, although the detail of the Section 106 and conditions may well affect the other points which have been made in writing. And so I just, if you like, leave that fairly neutral position on those other matters for now. So that was really by way of introduction. Turning then to the forest, the SAC, and the likelihood of adverse impact. Bearing in mind that a large part of Epping Forest is designated as a special area of conservation, i.e. a protected site under the habitats regulations, there's a hard-edged legal constraint in relation to the assessment of the appeal proposals. In the absence of interests of overriding public importance, which I understand are not claimed, consent can be granted only if the decision maker is satisfied that the proposals wouldn't adversely affect the integrity of the SAC. So that's the approach we've taken, sir. So as to be clear, that you need to satisfy yourself that the proposals would not adversely affect the integrity of the SAC. This is an SAC which is in unfavourable condition. Broadly speaking, the cause of that unfavourable condition is atmospheric pollutants. In order to make good what I say, see please the project HRA. I understand that the current version is December 2021, Section 5. So HRA 2021, Section 5. And in particular, see paragraph 5.7 of the HRA, which says this, which I've set out in my speaking notes, all types of traffic listed above may travel through the SAC and therefore increase the pollutant burden. Any increase in the levels of pollutants would be likely to harm the sensitive features of the SAC, especially the heathlands and beech forest on acid soils. Now, the Trust understands that the overall number of daily vehicles associated with the development exceeds 1,000. Daily employees attending the site would be, as we understand it, in the hundreds. Trip Distribution is dealt with in the TA. For example, we've seen Appendix 7 in Part B of that. A series of assumptions are made. We're clearly not in a position to go behind any of that. We don't lead expert evidence. But in short, a not immaterial number of employees would drive through the forest, I should add, in polluting vehicles, absent an effective means of control. And I'll come back to that point if I may. We again, you're going to hear the word concern a few times. I mean, hopefully some of these will be assuaged in the end, but we were concerned to see Natural England's position in their 8th of May letter. In particular, they made reference to the local plan strategies, and then they said, or if not, whether the additional mitigation measures put forward by the developer have sufficient certainty, effectiveness and enforceability required by the habitats regulations to deliver the target of a net beneficial effect on vehicular movements or vehicle movements on roads running within 200 metres of Epping Forest SAC. Again, I've set out that quote in the notes. Concerned about that because that certainly was an indication, as far as we were concerned, that they themselves have not interrogated the proposals in order to reach a conclusion on those matters. Effectively leaving it to you. Although I think they mentioned the council, it's unclear to me what evaluation the council has in fact undertaken. Perhaps we'll hear more about that. We're also unclear about the extent to which there's reliance upon the local plan proposals and the extent to which, aligned to that, the development is intended to be entirely consuming its own smoke, so to speak. And that lack of clarity is also apparent in the Natural England letter, in our view. Just as far as mode is concerned, mode rather than distribution, and just in terms of the likelihood of cycle or pedestrian trips, with local knowledge, we would just bring to your attention, please, for you to consider on your site visits, settlements east and northeast of Dowding Way, Epping, Thaden Boyce, we think probably Loughton also, further afield, Harlow in the same direction as Epping. We would just query the realism of non-car modes, particularly cycling or walking, because you don't have a cycle path between the appeal site and, say, the Epping New Road. It's also steep, and your pedestrian route would either be on the road where there's no path or, I think, within the forest itself. So our point really about this is that in the absence of a real prospect of staff walking or cycling, unlike other sites in the district, between the appeal site and the other local centres we've mentioned, then the question is for you whether they would be travelling by polluting vehicle, non-polluting vehicle, or by that DRT which is relied upon. So just going back then to the point that we were making, that absent an enforceable means of control, it is likely that there would be, in our view, a substantial number of car trips in polluting vehicles through the forest with consequential impact on its integrity, bearing in mind its current unfavourable condition I've gone through that paragraph at a clip. You'll have that paragraph entirely in writing. General observations. Brief comment is needed about what was said by the appellant, on behalf of the appellant rather, in opening. The verdict on the local plan proposals for avoiding impacts on the integrity of the SAC we had understood to be imminent, but we don't now know when that will be nor what those conclusions will be, and there were substantial objections, including on SAC grounds. So it would seem that the appellant, in coming before that process, in advancing its proposals before that process, I don't make any criticism, but evidently if you opt to do that, you take on responsibility for demonstrating that there's nil adverse relevant effect. And finally, on the opening, we don't accept that no development can come forward in the district if this site does not. This site is proximate to a range of centres where walking or cycling is unrealistic. Obviously, sir, for you, evaluating the merits of other sites is out with the scope of your public inquiry, but our local knowledge suggests that the submission ignores the potential for development in the district nearer to existing public transport hubs, or indeed development with less parking incorporated, and I'll come back to that. I'm going to now just air a gripe. The Trust's ability to participate in the process so far has been hampered for a number of reasons. One was the late provision of the Section 106, and happily, thanks to your agreement that we can make representations on that, that's been resolved. Unfortunately, the core documents list's not on the Council's planning application website, nor are the documents themselves, and members of the public, ourselves included, have been left actually unable to work out. We've surmised, but we were a bit worried we'd got things wrong about what might have been superseded. It's just not clear. We haven't had much help from the Council's website, unfortunately. Recent statements of common ground, they're not on the website. Natural England's most recent letter, we don't think that's on the website, although we got that separately, for which many thanks. Conditions, they're not on the website. Reference was made to conditions appended to the officer report, but matters seem to have moved on. And a couple of proofs, transport and on the DRT, they've been put in late, and we've seen them, but obviously quite late in the day. So, and I think even now there are early consultation responses from Natural England to which cross-reference is made in the later letters, which are still not on the Council's website. So all of that, I'm sorry to say, a bit of a complaint, but really it just leads to this point, which is that these observations now, representations, they're the best we've been able to do in the time available, bearing in mind all these various constraints. So, and now these are the key issues as far as we're concerned, as best we're able to articulate them in the circumstances. We start by observing that it's for the appellant to demonstrate that what would normally be the consequence of locating a significant trip-generating use next to the forest, i.e. additional polluting trips through the forest, wouldn't arise. And that seems to us to be the approach taken in Natural England's May letter, to which we would expect substantial weight to be attributed per the Smith case. In the circumstances, the Trust is concerned that there have been significant changes to the means of control for employees travelling in polluting vehicles through the forest, in that they seem to have emerged over the course of time, giving us some uncertainty about what proposal is maintained, what's been superseded. And a good example of that is the geofence technology versus the ANPR and barrier approach now, which seem to be favoured. But neither of those options, as far as we can see, if they are indeed alternatives, have been picked up directly in the Section 106, nor as far as we know in the conditions, although of course we can stand to be corrected on that, not having seen the most recent version. In the case of the latter proposal, the ANPR and the barrier, with a prohibition on a company's own employees commuting from where they live to work by car, potentially, no example has been offered of such a scheme used anywhere in order to show that this is effective and or enforceable. Not in the sense of, a planning Section 106 and a condition and a scheme to be improved. Clearly that mechanism is fine, but as between Next and its employees over the long term. We would observe that it's inflexible. It's not that you can't circumvent it. I mean, you could, for example, be dropped off by somebody else or by taxi to the gate. So it's not entirely foolproof. And in that way, I think the current proposals probably differ from the geofence technology, which was a bit intrusive, admittedly, but that was previously, we think, in prospect. And employees, of course, are likely to want flexibility. And so we just come back to that query about how that works in practice. And then as far as the DRT is concerned, on which considerable reliances must then be placed, we've got some queries, and we would ask, respectfully, sir, if you haven't already got these points in mind, that you would consider them with care when you hear the evidence. Firstly, what is the £4 million based on? There appears to be a single expression of interest referring to that figure, but we don't understand what analysis underpins it. Secondly, why 10 years? Thirdly, we've got in Appendix E to the most recent version of the transport proof, Appendix E, the coach scanner, there's a mere expression of interest, there's no conditional or contractual arrangement. There seems only to be one. And if I may be just permitted to be slightly ill-tempered about this, one point that really did surprise us, shall I say, was a diesel vehicle seems to be in prospect. That just, we really couldn't understand why that would be a favoured option. In our view, unless we've missed it, it's possible, but we've done our best to try and find it, but there doesn't look to be any proper assessment of viability provided to you, nor any real means of you assessing whether or not this proposal is likely to be viable post the 10-year period. And in our view, unfortunately, inadequate analysis of why 10 years would be sufficient, given that there are many areas of uncertainty in terms of what other relevant circumstances will pertain then. The Lubthorpe example, we might expect that to be more successful than here, perhaps, the Transport Appendix C, but what is actually said about that example is not particularly inspiring. So we've got some concerns about this, if this is the sort of answer to for people who might want to work at the appeal site but live in, say, Epping. If the DRT is the answer, then at the moment there are still a lot of unresolved matters relating to it, in our view. Just to say, we're on the downward slope now in terms of these representations. Bearing in mind, and this is particularly thinking about employees potentially coming from Epping, Thaden Boyce, we think Loughton, or further from Marlow, just ask you to consider, as far as the 367 parking spaces are concerned, we're not clear what is intended by next. Building them out, we think, unless we've misunderstood what's proposed, but then only having to demonstrate an operational requirement in order to use them. We're unclear in particular how that could pose a constraint to their future use, and Schedule 4 of the Section 106, unless we've misunderstood what's contained therein, doesn't seem to leave us much the wiser. Significant reliance has been placed on the next travel policy, Appendix 1 to the ITP, the Interim Travel Plan. We note the contents of paragraph 6.2, and we would suggest that in order for you to place weight on the legal advice referred to, you should have it disclosed. And this is particularly in relation to employment matters. We're unclear about whether or not that policy could be subject to later change if, for example, it proves unpopular with employees or creates difficulties in recruiting employees. It's unclear how it would be enforced through employment contracts or an employment law. We don't know, but we are worried about whether there could be a well-founded employment law concern about unfairness or discrimination. No specimen contracts being provided, no examples being given of any similar scheme working in practice, no written advice, and absent the detail of that, we would not be content for weight to be placed on that. And we say that just the mere fact of some internal legal review having been undertaken cannot really provide the requisite level of confidence in terms of that employment law aspect. In terms of leading counsel advice, I don't suggest that you go behind that, but I would assume that that's planning advice, and that's different, and I don't take a point on the mechanism. I'm not asking for that disclosure of that. That aspect's not controversial, but it's the specifics of the proposals within the Section 106 that we're interested in. We think even what is proposed leaves it all really to the local planning authorities, later assessment. And we are concerned about how in the circumstances you could have the necessary confidence, necessary certainty about impacts. And finally from me, until you get the written notes, I think a comparison is drawn between this sort of arrangement and HGV routing, but there's an important difference here, because here you're seeking to regulate how employees travel from their own homes to work, and in our view that's very different from HGV routing, which is much more conventional and well understood and works in practice. Because we don't understand it to be the same drivers for circumventing that. And we don't understand it to be the same complex employee relations potentially arising. So for those reasons, we are keen to see the next, all the detail we can really on the Section 106 and the conditions, in the hope that they address and assuage some of the concerns that we've articulated. But as matters stand, we are not confident that the habitats assessment would allow the grant of planning permission here.